Good morning, REMAX Distinctive. It's Dan Bouchard, REMAX Distinctive's supervisory broker for Maryland, and we are going to be discussing a source of income discrimination case today. So, without further delay, let's jump into it. The case is Hare versus David S. Brown Enterprises Limited. It's a landmark Maryland fair housing case decided by the Maryland Supreme Court. The case centered on Katrina Hare, an elderly and disabled African American woman who was denied a rental application because her income, partially covered by a housing choice voucher, did not meet 2.5 times the market rent minimum income threshold. The landlord required voucher holders to earn 2.5 times the entire market rent rather than calculating based solely on the portion of the rent that the tenant was personally responsible for paying. The practice resulted in an illegal disparate impact against the housing choice voucher holders, including Maryland source of income anti-discrimination laws. The Supreme Court of Maryland ruled in favor of the tenant, establishing that the rigid income formulas scaled to full market rent rather than the tenant's actual share unlawfully shut voucher holders out of housing. Landlords and property managers companies across Maryland are legally required to account for the housing vouchers strictly against the tenant paid portion of the rent when evaluating the financial eligibility. Whoops. While the parameters of the stated law are clear, they don't envision all the possible scenarios that can come as a result of violating the law. The devil is in the details. Agents often ask for a list of allowable and not allowable rules to live by in order to not get themselves and their clients in trouble. A noble and well-intentioned ask for sure. Government bodies, Maryland Association of Realtors, local associations, and legal counsel for any particular brokerage typically will not be willing to provide an itemized list of what is specifically and not what is and is not specifically allowed under the law. This is because every situation is unique and different from the last. As soon as a list would be provided, a litany of exceptions and outliers will change the outcome of such a list. As a result, the best that real estate brokerages can do is to state with clarity the clarity of the law and to coach agents away from the potential gray areas that event remotely get close to being discriminatory. So sorry for the grammatical problems there. Um, so as a best result, the best that real estate brokerages can do is to state the clarity of the law and to coach agents away from the potential gray areas. Um, and um, and so operating within the gray areas and trying to adhere to a strict guideline is what's going to get you into trouble more times than not. And that's the point of that conversation. All it takes is one consumer complaint, which may or may not be a tester, or to result in an investigation into your practices, which will then require the agent to have to defend themselves with or without an attorney. And then the burden is on the agent to have to prove that they didn't discriminate. The burden is far more difficult than agents assume, and it usually results in serious penalties, legal fees, court costs, and worse. Stay as far away from the gray area as much as you humanly can in the conduct of your of your business practices. When we try to find the line in the legal sand, we are playing with fire with our wallets, our licenses, and the best interests of our clients. So when we're talking about trying to establish parameters for what a landlord will and will not accept, it's better to be specific about what is going to be used as a guideline to accept a lease, and then to be specific about what is going to be used as a guideline to reject a potential lease, and make sure that those are compliant and don't don't even come close to the standards of any fair housing protected classes. And by staying clearly away from there, if there's any doubt in your mind that there is going to be a potential um, uh, getting close to the potential line of what is and is not allowed, I think your judgment should default to caution rather than to try to play yourself right up to what may be perceived as a line in the sand. And the and so stick with the concepts of what is written into the law. And if it feels to you like it's going, that it is, if it sounds like you need to ask a question, if I do X, Y, Z, is it going to be in violation? Chances are, if you came to me with that kind of question, I would probably tell you that there is a legal argument, there could be an argument for a complainant to feel like there was some kind of discriminatory action against them. And all it takes is that complainant to file that complaint and to start the investigation, and then we as a brokerage and you as the licensee would have to defend yourself in terms of fighting that complaint. And most of the time, the tenant's going to win in these cases. So don't even try to play with the gray areas. Stay as far away from the gray areas as you can. If there's any doubt, don't use that standard or condition. It's okay in Maryland to use the content of the credit report itself. It is not okay to use the credit score. You can use things like account late pays, collections, bad referrals, you or bad references. You can use things like inconsistencies in the contract application, so that if there's something that was stated in the application and then the credit report reveals something different, that kind of inconsistency could probably be a legitimate reason to deny an application, or at least to go ahead and ask for an explanation on this. I would probably defer to going ahead and asking for some kind of an explanation rather than to outright deny an application because of an inconsistency. So let's just make sure that we stay clearly away from those kinds of guidelines. We can't impose income restrictions when it comes to vouchers. The only kind of income restrictions that you can impose is the tenant paid portion, and other similar kinds of things. If there's any question, feel free to give me a call, but we really need to stay away from operating in the gray areas. If it smells like a fish, it looks like a fish, it's probably a fish. So, if you even have to ask the question 9 times out of 10, I'm probably going to say stay away from it. Anyways, give me a call if you have any questions. Thanks. Take care.
Hey Dan,
Yes.
are you recording? Like, can I talk to you if you stop
Yeah,
the recording?
hold on, let me stop.
I'm probably the
Um,
only one on here.
could be.